Today let's talk about jury argument, or in the words of Hamlet, to object or not object. That is the question. As you probably know, almost any jury argument needs to be objected to if you're ever going to complain about it later. There are a few exceptions for appeals to racial prejudice, ethnic prejudice, maybe unfounded personal attacks on the opposing counsel, though it's questionable whether that one still survives. But if you don't object, the jury may think you're acquiescing in the comment, unless you have a chance to stand up again and correct it. If you do object, what happens if the judge sustains it? Well, then you've made the other lawyer look bad, and supposedly the jury won't consider it, but you have called attention to it. Maybe they were dozing off and now they're awake. On the other hand, if the judge overrules the objection, which so many do, as we all know, they leave it pretty wide open in jury argument, then the jury's going to think that your objection was improper, that the statement by the other lawyer was completely fair. Maybe they think the judge has endorsed what the other lawyer said. And if anything, you've implied that maybe you're the miscreant in the crowd by trying to interrupt the other lawyer's presentation. So there are a lot of reasons why you would choose not to object, even to things that are objectionable. The one saving grace is that there are very few cases reversed for improper jury argument. Most of the times that they are reversed, it's because they're incurable appeals to prejudice in the first place. There are a few cases that have reversed on jury argument, so you need to think beforehand, what kind of judge do you have, what kind of opposing counsel do you have, and what will be your strategy for objections. But if you try to wing it, you're liable to make a mistake. See you next week.